Hi everyone.
Hello. Very good.
Ansh, Sagar,
Yes, ma'am.
shall
Yes,
we
ma'am.
begin? Good
Yes, ma'am.
afternoon, Mr. Ritwik.
Ma'am,
Hey,
we'll
good
begin
afternoon,
shortly.
ma'am.
How are you? Nice to see you.
Likewise. Very good to meet all of you, ma'am and Dr. Rohit. Thank you so much for having me,
Thank you, sir.
uh,
Welcome, sir.
and university as well, of course. And my thanks also to my professor, Dr. Suvarna Nilak, who made this possible.
Thank you.
Yes.
Thank you.
We'll just start in a minute, ma'am.
Sure.
Right.
Shall we start, ma'am?
Yes, please.
Okay. कर्मण्येवाधिकारस्ते मा फलेषु कदाचन मा कर्मफले हेतुभूर्व ते संगो सत्वकर्मणि. Meaning, you have the right to perform your duty, but not to the fruits of your actions. Do not be attracted to the results, nor should you be inclined to to inaction. So, with this, we start with today's session. Over to you, Priyanshi.
At this juncture, it is our privilege to extend heartfelt gratitude. We are deeply thankful to our Dean and Principal, Dr. Ujjwala Bentale Ma'am, our Vice Principal, Dr. Jyoti Dhar Ma'am, and our IQEC Coordinator, Dr. Vidya Dhere Ma'am, for their unwavering encouragement and constant guidance. Our sincere appreciation also goes to our respected professors, Dr. Rohit Services Sir and Mr. Shubham Tripathi Sir, for steering this program with such dedication. I would like to now invite Principal Ma'am for her words of wisdom and the inaugural speech. Thank you.
Thank you, Priyanshi. Thank you so much. And good afternoon, everyone. And welcome to the Skill and Capacity Building course on Arbitration Saamanjasya, which is organized by Bharati Vidyapeeth, deemed to be University's New Law College, Pune, and very well coordinated by Dr. Rohit Survasi sir and Mr. Shubham Mishra sir and the whole team of students. I'm not going to take up everyone's name, but yes, Priyanshi and Ansh, Sagar and all, you have been doing wonderful. And this is, I believe, this is the 7th day of our program, and we are really wonderfully doing the things. And on behalf of Bharati Vidyapeeth and the whole fraternity of law, I wholeheartedly welcome today's resource person, Mr. Ritwik Kulkarni sir, who is the Principal Associate, Dispute Resolution, Khaitan and Company, founder, Coins. So, here, so welcome. And you are very well aware that this particular course, Samanjas, is more than just a learning experience. It is a step towards shaping the future of arbitration and conciliation in India. And also, you know, it is to nurture the legal minds and intellectual minds, and practical expertise is being given under the umbrella of ADR system in our country. This is all possible because of our founder chancellor, Honorable Mr. Patangrao Kadam Sahib, who had the vision in I can say 1960s, and in 1964 he established this Bharati Vidyapit University, and he wanted this university to grow in as large as it could be, and today it is. And so we are so proud that under the legacy of this university, we are really building up the whole understandings of law, and we are also being guided and supported by our patrons, Professor Dr. Shivaji Rao Kadam sir, the Chancellor, Dr. Vishwajit Kadam sir, the Secretary and Pro Vice Chancellor, Professor Vivek Sauji sir, the Vice Chancellor, and Professor Dr. Asmita Tai Jagtap, the Executive Director of Health Sciences. If you are aware about the Law College and about Bharati Vidyapit, I am very sure that you are aware that we are multidisciplinary and we are multi-talented university. And
Yes,
this
of course.
university is having a history of more than 40 years with campuses in Pune, Navi Mumbai, Kolhapur, Solapur, Sangli, Karad, Panchgani, and you go on, and in New Delhi. It's very well established. The New Law College was founded in 1978 and was inaugurated by Honorable Mr. Justice Y.V. Chandrachud, the then Chief Justice of India, and we are recognized for excellence and legal excellence throughout the country. We are among the top law schools throughout this particular country, and we are amongst the top three private law institutes throughout this country. As well, we see that our students are groomed very diligently and dedicatedly by the staff, and the students themselves. They contribute and they initiate this particular activities, and they are part of many different 15 cells. To name few is this ADR cell, then the environment cell, the artificial intelligence cells, and so on. So some law as such, you are aware, you are practicing into, and ADR is a system wherein we know it is a huge sea, and bit by bit every student will add on towards its understanding. And that is the reason why the title given to this course is skill development and capacity building. So I believe with your expertise and expertise of all different authorities who have been around for last 4 5 days, the students have understood and are enlightened, and today also they are going to get enlightened at a very, you can say, larger level. So once again I welcome you, and I welcome everyone to be part of it and to give a patience listening and have analysis of what actually this area system will help us in coming future, where we have full whirlpool of cases pending around and cases coming up. So here this ADR system is going to really help the students in the coming future. So thank you so much, and over to you, Priyanshi and Ansh. Thank you once again.
Thank you, ma'am. Thank you, ma'am. Thank you so much. So, on this sixth day of our course, Saamanjasya, we step into an extremely crucial aspect, that is Falsiddhi, which reminds us that winning a battle, or in our case, winning is not enough. True justice lies not just in achieving a favorable decision, but in its enforcement, in making sure that what is rightfully decided actually transforms into reality. Just as Lord Krishna tells Arjuna in the Gita, one's duty does not end with the action alone, it extends towards the ensuring the fruit of rightful action benefits society at large. Arbitration too is not complete with an award, it must travel the path of execution to ensure faith in justice. Today's session is designed to explore exactly this, how an arbitral award is enforced, how challenges arise in its execution, and how the principles of justice are safeguarded beyond the verdict. With these thoughts, let's us move forward in today's enlightening session on Falsiddhi. Winning is not enough, enforcement is essential. Over to you, Ritvik sir. Please guide us with
Thank you so much.
enlightening lecture.
And
Thank you, sir.
my greetings to everyone who is present here, especially the members of the institution, Principal Ma'am, Dr. Rohit, and the students who have contributed to the organizing, all the way up to the Chancellor and the people who are involved in the setting up of the university as well as the New Law College. It's a phenomenal institution, and I believe it's based or at least has a very good presence in Pune, which is very close to my heart because I studied in ILS. And as I mentioned earlier, my thanks also to my professor, Dr. Suvarna Nilak, who also was part in making this happen in terms of the coordination, etc. So once again, thank you so much for inviting me to this phenomenal educational institution who's making the minds of tomorrow, and for the chance to contribute a little bit in this large pool of knowledge. So I find it very interesting. Yes, this we were just discussing, and we started with a couple of lines from the Gita. The one that perhaps we can also keep in mind is that Lord Krishna also tells us that what is important is that we think of not the fruits but the action, that it is our duty to keep performing action, and that's very relevant as far as we lawyers are concerned, because today we are going to deal with the session called Phala Siddhi, which is the fruition of what the fruit that we have. Now, it doesn't, I don't believe it means that we should, completely ignore all fruits as such. Because when we do action, and as a lawyer, your action is to, use your knowledge to help your client and to ultimately towards the end of justice. Justice is the fruit, that is the phala. So, in case of constitutional matters, justice is when freedom, non-arbitrariness, and all these kind of actions are upheld. But in commercial matters or in private matters, justice or the phala is when the right party is and their rights are upheld. So by now, I think you have already all crossed that stage of how the arbitration actually works, and experts have already taken through all of that, including the arbitration agreement, etc. So today I thought we will discuss uh, broadly three things. One is, and I know there's a lot to cover, so maybe I may not be able to cover everything specifically. I will share my email ID. So if there are any questions later, you can please feel free to send me an email. But the three things that I was thinking of covering is, number one is the drafting of the arbitral award. What does the phala contain? And for it to be impenetrable in the sense that you have a valid arbitral award, you have a good award that is not susceptible to a challenge from an award perspective, and what a party should ensure in doing that, or as an arbitrator, if you, because tomorrow some of you, when you get take part in ADR and you become ADR lawyers, subsequently you might become arbitrators also, hopefully. So that is also something that you might want to keep in mind as to how an award is drafted and what is contained in an award. The second part, of course, is the part of where we go and consider the challenges to an arbitral award, because it's not that once an award is made, it is completely fine, in the sense that it can be just taken on it by itself. There, the law still provides for a certain further process. And the third is the part of actually seeking execution, which is the siddhi as such. So, and please, during the meantime, if you have any questions, please note them down. If you ask me during, also it's fine. And if I'm going too fast, please do tell me. I will taper it accordingly. Now, to start with the award, if you see the Arbitration Act, there is no specific definition of an arbitral award. All it says is that an arbitral award includes an interim award. So there is in keeping with the broad sense of flexibility that you give to an arbitral tribunal in terms of their procedure and other aspects, there is a little bit of flexibility in terms of what you include in an arbitral award as well. So that said, there are certain minimum requirements of an award which you can find in Section 31 of the Arbitration Act, read with Section 31A of the Arbitration Act. You should also read an award with the grounds for challenge, because as in how you, and we will discuss the grounds of challenge, etc. When an award is being drafted, or even when an arbitration is progressing, one should always be mindful of the possible challenges that can be raised right at the time of commencing the arbitration. So that will percolate into the award when your parties are making submissions. If you are the see, one of the things that we also should keep in mind is that, yes, Phala Siddhi for the person who wins the arbitration is execution, but Phala Siddhi for the person who loses the arbitration is perhaps, and maybe wrongly loses it, for that person, the Siddhi will be getting it set aside. So you have to think from that perspective also. Both the things are going in parallel. And each has to prepare for each other. So the person who's going to win needs to protect the award, and the person who's going to lose needs to find out right in the beginning throughout the arbitration to bring out points which, according to them, will ultimately lead to the award being set aside if they're being treated unfairly, etc. So we discussed section 31. So let's just, before we go into the statutory provision, let's try and understand what kind of reliefs or remedies are generally sought. uh, See, arbitral or arbitrations generally are, though they can extend to legal relationships which are not of commercial nature also, mostly it is they deal with the commercial matters. So what kind of reliefs can you ask? Because when you participate in an arbitration, a party has to set out what they want. That's very simple. uh, some There is no specific limitation in the Arbitration Act for the kind of reliefs that you can seek. The one of the ways that you can find out what the arbitral tribunal cannot do for you is to examine arbitrability, whether something is arbitrable or not. And I think that is also something you might have already come across in the last 5 days as to what can be arbitrated, what cannot be arbitrated, whether it can affect third parties, etc. Tribunals generally cannot grant relief that extend to people who are not part of the arbitration, directly or indirectly. They cannot affect third parties. So the reliefs are circumscribed by the arbitration agreement. Now, within that scope, there is no real limitation as such. Commonly, what people ask for is, for example, in a contractual dispute, the first thing that you would ask for is a declaration. You will ask for a declaration that the counterparty has, by doing whichever act that you think is violative, has breached the contract. So, number one, you will say that kindly declare that a party has breached the contract. What follows will be based on this finding and this order that there is a declaration of breach. You may, in a particular case, you may ask for compensation. So it may be an order of money, which is like a money decree under the CPC and a civil suit. You may ask for injunctions, where the tribunal may direct the party to do something or refrain from doing something. Is what we call an injunction. Or there could be an order of specific performance, where if there is something agreed in an agreement, that let's say there is an agreement to sell a piece of land, then order of specific performance would be that you have to take all the steps necessary to come to the table, sign the agreement, which you were not doing before, and ensure that the land is transferred, take all necessary steps to ensure that ultimately the land parcel is transferred and the title is also transferred to the person who's asking the relief. So these are the broad reliefs. There are ancillary reliefs also that are sought, and these can be granted. For instance, when you have an order of specific performance, you believe that the party, even if you get an order of specific performance, will not come to the table and sign the agreement. Then there are instances where you request for a relief that a receiver or a court receiver or a private receiver, which is a authority who is appointed by a tribunal, that receiver on behalf of this counterparty comes and signs the agreement and ensures that your rights are fulfilled. So these are the broad kind of reliefs that you can seek from an arbitral tribunal. Now, what kind of awards are passed? So if you juxtapose it with decrees, it's not very different. But there is, again, because it is arbitration, there is more flexibility. So as I mentioned earlier, the only awards that the Arbitration Act itself refers to is a final award and an interim award. Now, this is a little important because there are a few shades to these terms. Okay. Now, let's start with the final award. a final award will be the last award that is passed, and that is as per Section 32 of the Arbitration Act. Once a final award, which is the last award, the last final award, is passed, the proceedings come to an end, and the arbitral tribunal becomes functus officio, meaning that the official function of the tribunal is over. They have no statutory power anymore. The proceedings have concluded. After the proceedings are concluded as per Section 32, there can be no further arbitral proceedings unless there are certain limited circumstances when you have there are clerical errors, etc., which you have to get corrected pursuant to Section 33 of the Arbitration Act. So that is where the last final award is important. That puts an end to the arbitration. But not all final awards are the last final award, right? Why? Because what can happen is there are, because of flexibility that is available to a tribunal, there can be partial awards, which is an award that does not put a quietus to the entire dispute, but an award which deals with a specific aspect of the arbitration, but in a manner that is final. So finality is still attached to that part of the award, but it is not going to finish the arbitration, in simpler words. What kind of awards would those be? So it is possible that in certain cases, when there are, say, for example, jurisdictional objections, and this also is something perhaps that you have already gone through in your earlier lectures on when jurisdiction of an arbitral tribunal can be challenged, who can challenge it, what are the grounds, etc. So, as a matter of practice, sometimes what happens is, and this in one of my very recent arbitrations where we are now waiting for the award, okay, what happened was that the respondent, we were for the claimant, they are for the respondents. The respondent said that we have an objection on grounds of jurisdiction, and which we said, of course, is not tenable. But they said that whether it is tenable or not, what we request the tribunal to do is that you bifurcate the proceedings, meaning you split the proceedings into two sections. One is you decide first whether you have jurisdiction or you don't have jurisdiction. And if you find that you don't have jurisdiction, then the whole matter will come to an end. Don't make us file pleadings on merits, witness statements, and incur costs on expert reports, etc., etc., etc. And we argued that there is no need for something like this. But as a matter of course, this is a response that we had to give. But otherwise, it's not going to affect us or prejudice us in any manner. It helps if there is a bifurcation in certain cases. In this case, it helped, not all cases, because it causes delay. If you bifurcate the proceedings and you wait for the jurisdiction decision, the whole timetable can get pushed. So it is a matter of strategy and the case that you are dealing with. Ultimately, what happened is that the tribunal bifurcated. So there was an order that the proceedings have to be bifurcated. So first they'll deal with jurisdiction, then they will deal with merits, and they will deal with whether any damages, losses have to be paid. They did that, and they passed an order on jurisdiction saying we do have jurisdiction. So we went through on the jurisdiction aspect. In our case, it was not passed as an arbitral award. So it is not a partial award. If we want to, or somebody has to challenge it, one can argue that because it finally settles the principle of in our jurisdiction in our proceeding, it should be treated like a final award, a partial final award. But there was no challenge in our case. But you could perhaps treat that kind of a decision as a partial award, where jurisdiction is finally settled. That is not going to change in the final award. Okay. And now what we are left with, for which we are waiting an award, is the merits and the losses. So that will finally, that award, once that award comes, it will be the final award under Section 32 of the Arbitration Act, and then the full proceeding will come to an end. So that is how we approach a final award and something that is within an award. I think there's a question which says that can you show us an example of an arbitral award? I don't have one right now, but I can definitely share so that we can all look at it. There are many awards that are public. For example, if just off the back of my mind, I think if you search for the award in Zostel versus Oyo, you might find it online. There are some more questions on whether we can challenge the arbitral award on jurisdiction. That's a very important question. Please hold on to that, Devu. We will come to it. Okay, when we discuss section 34. So we were dealing with what is a partial award and a final award. What is an interim award? If you look at the Arbitration Act, what they say is, or if you look at judgments as well, for example, in McDermott International versus Burns Standard Company, is an interim award is something on which a final award can be made. So they are dealing with something at an interim stage for something that you can deal with at a final stage. I'll give you an example. So in one of our arbitrations, there was a parallel civil proceedings that was commenced, and the one of the parties challenged this action of taking parallel civil proceedings when you are already part of an arbitration, to say that this is a breach of the arbitration agreement, that you cannot go to a civil court when you are already arbitrating and you are bound by an arbitration agreement. Because ultimately, when you agree to arbitrate a dispute, that is also a contractual agreement. And any loss that arises from you not complying with your agreement to arbitrate can also be compensated. So it is an independent contractual agreement by itself, apart from the Section 7 requirements, etc., which you would have already discussed. So the party claimed costs, whatever they had. First of all, they sought an order that you have to delete us from the proceeding, and we sought that the costs be paid for whatever we had to. We had to engage a lawyer, we had to go to that court, we had to draft things, etc. And this was a proceeding filed before the tribunal. Ultimately, this is an interim stage. So the tribunal at that stage held that, look, we are not going into the final question of whether there is breach, etc. But what prima facie there is a breach. So it is an interim finding. Prima facie there is a breach. As an interim proceeding, get these people deleted, and an order of costs will be paid. You have to pay 50% of the costs of whatever they had to spend in the arbitration and in the civil proceeding defending themselves. And then later on in the final award, we will see. So in the final award, they can reconsider this, and where they can confirm this finding and say, yes, it's the same. Or they can say, ki, we are now going away with this. We don't agree. It is not a breach, and the cost should be returned. Ultimately, in the final award, the main claim was actually dismissed against them, but this award was upheld. So it became final at the stage of the final award. So that is something like an interim award, if you want to consider. Now, what are the formal requirements of an award? If you look at Section 31 of the Arbitration Act read with Section 31A, you will see what are the requirements that statutorily you must have in an arbitral award. So let's go through those quickly, right? The first most important, and I'm not taking exactly one section, but I will cover it broadly. So you can look at Section 31. It's better if you have the Arbitration Act before you when we are discussing it. So we are now looking at Section 31. Of course, the number one thing that it has to be is it has to be written and it has to be signed, the award. The Arbitration Act requires that generally an award be passed as a majority award. So if there is a 3-member tribunal, then the final award should be passed by a majority. It should not be that 3 people have 3 different views. So in a majority award also, what the act says is that it should be signed by the majority, it is okay if the minority member does not sign it, but reasons should be recorded for why the minority member is not signing the award. There are exceptions, very, very, very rare exceptions, where instead of the majority award, the minority award is actually upheld, which I believe happened in Sangyong in 2019 in the Supreme Court. Just see Justice Nariman's judgment in Sangyong Engineering. We can discuss the specific judgments and the names, etc. And perhaps we can later on circulate a list of the citations of whatever judgments we have discussed so that you can take it up later. But otherwise, as a general principle, the award has to be signed and passed by the majority. The second, and of course, the most important requirement is that the award has to contain reasons. Without reasons, an award will be on very weak grounds. That is very obvious. The only times when the award is okay not to have reasons is when the parties agree specifically it's fine, we don't want reasons. Or the other is when the award is a consent award, which is that the award actually, the arbitration ends with parties coming to a settlement. And what amounts to a settlement, how do you get to an consent award, is you will see at section 30 of the Arbitration Act. And that is, of course, a separate discussion. But the basic point is that when at any point of time, when you are arbitrating, whether it is the starting stage, middle stage, any time before the final award is passed, parties are free to try and attempt a settlement. And if they do come to a settlement and their signed terms of settlement are submitted to the arbitrator, then those terms will become the basis of the award, which will be a consent award. And then the arbitrator doesn't have to give any separate reasons. It will be passed on the basis of whatever the parties have agreed. These are the only two situations where the parties themselves agree no reasons are required, and where there is a consent award, that the arbitral award does not have to have any reasons, but otherwise it has to contain reasons, without which it can become susceptible during challenge. The third important thing is that the award needs to contain the date and the place for where it is made. Now, one might think that these things are small and very obvious, but they do become important sometimes, when especially there is a dispute about where the arbitration was seated, or what was the venue. You might have already discussed some of these aspects. What is the seat? What is the venue? Which is a place, etc. So during the arbitration itself, if the parties have brought up this question of what the seat is, what the venue is, etc., sometimes in certain cases the parties even request the tribunal to, instead of sitting at Mumbai when the seat is Mumbai, they want to sit in Bangalore or Delhi or something else. So they may request the tribunal to shift the seat mutually. So all these things can get sorted because the tribunal ultimately passes an award based on where it is passed, and that will be deemed to be the place of arbitration as per section 20 of the Arbitration Act. Why is that relevant? Because this controversy will lead you, or rather become relevant, when you go to the challenge proceedings or enforcement proceedings at the stage of 34 or 48, as the case may be. Uh, because the court that will have jurisdiction will be affected by what the place of the arbitration was as per the award and as per the parties' agreement. Now, the next important thing is that the award has to be delivered to the parties. It can be, this again sounds like a very formal and obvious requirement, but why it is relevant and why it was necessary to say that in the Arbitration Act is that once the award gets delivered and once the party is in receipt of the award formally, then your clock begins to file a challenge to the award. And the clock is, it's a very limited amount of time, which we will very briefly discuss at the 34th stage. You have only 90 days to challenge it, and then you have 30 additional days, provided that you can explain the delay. After that, you cannot challenge the award. So that is very strict under 34. That's why it's important that the award must be delivered to the parties. The next part of course, if you in section 31 subclause 6 is that the tribunal has the power to make an interim award, which we just discussed, on any matter which they can make a final award on. So that is already something we have discussed. Now, two more important things that have to be a part of the award. One is interest. Now, the tribunal has two powers of granting interest. Number one, if you see 31(7), number one is subject to parties agreement. Number two is not subject to parties agreement. So 31(7)(a) starts with the phrase unless parties agree otherwise. And B does not start like that. Now, the first one is that unless the parties agree otherwise, the tribunal has the power to grant interest at a rate that is that it deems fit from the date that the cause of action arose, that is when the dispute arose, roughly when the dispute arose, till the time the award is made. So, for example, let's say that I have a contract with someone to buy some goods. The day that that person refuses to send me the goods, from that day till the day that the arbitration is concluded by way of final award, I will be entitled to get interest because I have been deprived of this money or the goods in this case. I would have made use of those goods. So that is what we call interest by way of compensation. I've lost that amount of money. I could have used the money to put in a fixed deposit. I could have used the money to invest in mutual funds or something, wherever else where I would have gotten some returns. But if the parties specifically agree in the contract, and that happens, parties sometimes agree that there will be no payment of interest during the course, or no payment of interest for any amounts that are owed under the contract. In those cases, the tribunal does not have the power to grant interest. If it does grant interest, it may be that component of the interest may be set aside. So this is also something that you might want to consider while drafting the contract, or if you see this clause in a contract when you go ahead, that if the parties have agreed no interest will be due under the contract, then the tribunal will not be able to give interest from the date of the cause of action till the date of the award. Now let's come to the second part. The second part is 31(7)(b) of the Arbitration Act. That is the power that, pursuant to the law, that is the statute, gives the arbitral tribunal to award interest after the award is passed. So let's just look at that. Okay. Yes. In fact, it says a sum directed to be paid. Any sum that is directed to be paid by an arbitral award shall, unless the award otherwise directs, carry an interest at the rate of 2% higher than the current rate of interest prevalent on the date of the award, from the award till the payment. There's also an explanation for the current rate of interest, which is at the first explanation, and you can find it's linked to the Interest Act. So this is interesting because it's not this interest will not be an amount that is paid under the contract. So you can't agree to it. This is an interest that has to be paid under the award. So the only person who has the choice of not granting this interest is the tribunal. But unless the tribunal specifically says no interest should be granted, interest will apply on the award amount that is given. Some practical issues come into picture when you see it. There's no specific number given here. Okay, it says 2% higher than the current rate of interest prevalent on the date of the award. Now, how do you find the current rate of interest? There are a couple of ways. One, of course, you will see the definition of current rate of interest in the Interest Act. But broadly, what happens is you check the interest rates that are charged by scheduled banks, by nationalized banks such as SBI, and you see the overnight lending rate, etc. So if you see, say for example, and it has to be current, right? So you will go to the website, you will check the rate, and this is important for you also as a lawyer and a pleader while making the request for interest, because you have to satisfy the tribunal that this is the rate of interest. Please grant us interest 2% higher than this. So you will go to the website of the SBI, you will find the right interest rate, and you will ask for 2% more than that. So that is the rate which will apply. And this is not subject to parties' agreement. It is subject to the tribunal's decision. Now, the last but not formal requirement, the last formal requirement is costs. Now, this is very important. I think previously section 31(8) was, it said the tribunal has the power to give costs, but now section 31(a) has a very comprehensive regime about granting costs and the extent to which costs are determined by parties' conduct, etc. The overarching principle which you might have heard before is that the losing party has to pay the costs of the successful party. But this is a very blanket principle. Okay, what happens in an arbitration is like, an arbitration is very much actually like the Mahabharata, the whole of the Mahabharata. Okay, there are many battles in the arbitration. Some battles you will win, some battles you will lose. Final battle is Kurukshetra, which the Pandavas won, but there would be some of the little battles that they would have lost. So, for example, during the dice game with Shakuni, they lost that battle. Therefore, it is not always straightforward. So, just because, say, you win the whole arbitration doesn't always mean that you will be paid the entire cost. Some of the things that will play into this is, if you filed frivolous applications during the course of the arbitration, say if you challenged jurisdiction, if you knew that you were not going to succeed, there is no case. But just because you thought, or maybe your client told you that, I want you to challenge the jurisdiction. No, just do it so that you cause delay and you file it. The tribunal is always looking at conduct. Especially the most highly trained arbitrators, they are looking at everything that is being done. If there are frivolous communications that are going, if there are frivolous applications that are filed, something that does not have merit, if documents are suppressed by parties, if misleading allegations are made, if the tribunal is misled, after doing all this, if you win the arbitration, you may not get the costs. So all these things play into what happens at the costs award. And just like the merits phase, cost is also a very important stage of the judicial determination. So if you ask me, let's put it this way, that the first most important adjudicatory determination of the tribunal is going to be whether this arbitral reference is maintainable or not jurisdiction, whether it is maintainable or not. So, for example, whether the case is within limitation, outside limitation, if it's arbitrable or it is not arbitrable, that's maintainability. The second bucket will be jurisdiction. That do we have jurisdiction? So that is a decision on jurisdiction. The third is on merits, which is what the specific claims that are made, and whether there is breach of contract or not, whether there is a cause for compensation, etc. Okay, that is the third bucket. The fourth bucket is what should be the quantum of damages. If it's or the relief, whatever the relief has been granted, how do you assess, how do you measure, how do you calculate the amount of money that should be granted? Once you have established that there is liability, then you move on to the stage of quantification. And quantification has its own procedure, has its own legal principles, has its own financial principles. So, in many cases, what happens is that parties engage experts who give evidence. When it is a case for, if a company is involved and you want to exit the company, then maybe you will have an expert who will conduct a valuation of the company and say the company is valued at 500 crores and you are a 20% shareholder. Therefore, you should get compensation of 20% of 500 crores. And the other side will choose their valuer, so on and so forth. So the fourth bucket is quantification. And the fifth bucket is costs, where you make a determination, which as we discussed, on these various elements of how the parties have conducted themselves. What could you have avoided? Could you have made this faster? So in more sophisticated arbitrations, what also, or with more sophisticated arbitrators, one of the things they will also consider is if a party has made a genuine effort to come to the settlement table and speak to you and get the matter settled amicably, but you have unreasonably not accepted the settlement or denied the settlement or caused delay in the settlement, then that will also add to costs. So when you file for cost submissions, there is a whole different procedure for it. A very detailed submissions have to be made for every money that you have spent. You have to prove how much you have paid your lawyers, how much you have paid your expert, how much cost you could have saved, so on and so forth. So that is why Section 31A has an entire regime in itself. So this completes our discussion of the formal requirements of an arbitral award. Outside this, there are a few additional formal requirements. Number one, an award also has to be stamped because it is an instrument under the Indian Stamp Act. It is also an instrument in the Maharashtra Stamp Act. So the Indian Stamp Act, I think, requires 500 rupees of stamp duty. This will be different in different places. So Delhi has its own regime for stamp duty. Maharashtra used to have stamp duty of 500 rupees. Now, very recently, there has been an amendment. So awards are also stamped on a pro rata basis, meaning a percentage of what has been granted. If the award is not stamped, at the enforcement stage, the court will not act on it. Court authority, whichever authority, even if somebody doesn't challenge it under Section 34, if you take the award to any authority and they find that there is no stamp duty paid on the award, then they will not execute it. So stamp duty is very important. If an arbitral award deals with immovable property, if it comes out of a lease deed, if it comes out of an agreement to sell a piece of land, then it also has to be registered under Section 17 of the Registration Act. The award has to be registered as well. If you don't, then again, it will not be treated as evidence for execution or any other reason. Now, it's important for us to understand that not stamping or not registering the document is not a ground for setting aside the award. It is more of a formal defect which can be cured. In most cases, it can be cured, but it is not a ground for setting aside the award. Okay, just 1 second. Yeah. Let's now move to the drafting part of the award. Some of the things will be overlapping, but let's discuss how we go about drafting an award. Okay, now the first, of course, some of the formal requirements is you will draw a cover. Okay, now you put yourself in the shoes of an arbitrator. You will prepare the cover page. The cover will have the cause title of the arbitration. If you are in an institutional arbitration, then most likely there will be a serial number also. Say MCI so and so so and so. Then name of the institution, or if it is ad hoc, then there will be no name. The name of the arbitrators will reflect name of the parties, their roles in the arbitration, the legal counsel, all the legal counsel who are involved for the claimant and for respondent, the date and place of the award. So this is where we previously discussed that it has to have the date and place. This is where it would have the date and place, most likely in the cover. Then you start with the introduction. Now, okay, let me clarify. What I'm saying is a matter of is more like a guideline because it is not a requirement. It is something that I have seen in awards, etc. It's not that if you don't cover everything like this in this exact manner, your award will be bad or it will not be upheld. But generally, this is how awards are. So, in the introduction and summary, you will of course set out the procedural history of the arbitration, meaning you will set out when the arbitration commenced, when the arbitrators were appointed, if there were any interim or emergency proceedings, what happened in those proceedings, if there were any interim applications, what happened in those applications. You will set out the orders on this date, so and so order was passed. We passed a procedural order. We then passed an order dealing with a particular application, so on and so forth. And then all the way coming up to the passing of the award. Why this is important is that when you're drafting the award, you want to make sure that it is very clear that all the things that the parties have had to say have been dealt with completely and fairly, both the things. So it increases the chances of fortifying the award. So that if it goes to the court, then the court can see it's right there that on this day they filed a jurisdiction objection. That objection was dealt with clearly, and then it was not set aside. So and so, so and so, so and so. So setting out the procedural history is a very important part of an award. It should also indicate the other formal requirements in the introduction and the summary as such, as to what you set out the arbitration agreement again, so that it clarifies that there was an arbitration agreement, the place or the seat, and other whatever formal other requirements are, the applicable law, the governing law, etc. All these things should be set out at the introduction summary stage. Then, of course, there will be a factual background. That may be detailed as well. It may be taken from or inspired by the party's submissions. But what tribunal should avoid, I suppose, doing is to just copy paste or pick up from any written submissions or list of dates, etc., which are submitted to the tribunal. I don't think anyone actually does that, but it's just a cautionary point. Then, of course, after you deal with the factual situation of how the proceedings have or the dispute has arisen, what was the cause of action according to the parties, etc., and you come to the part of the issues and the claims that have been raised by both the parties. Broadly, what is the claim and what the tribunal is required to decide. Sometimes in arbitrations, tribunals ask you to submit a list of issues. Uh, Sometimes parties agree, they can consensually agree that yes, these are the issues. Sometimes they don't agree. But the tribunal ultimately decides based on what it thinks are the right list of issues in the arbitration. So they can set the issues out. After that comes the meat of the matter, the reasoning, right? Now, the reasoning, there are two ways you can go about this as a tribunal, I suppose. One is you go right into the matter of what the tribunal believes and sets out its analysis based on the facts. The other, which is a longer but more common way of going about it, is that you deal with each issue. You set out the first issue, and you say you make a summary of the claimant submissions. That claimant said this, and it will be linked to whatever is said in the written submissions, pleadings, etc. The claimant cited this law, this judgment, so and so, so and so. In response, the respondent submitted this, and then you go to the tribunal's analysis to say the tribunal believes this for these reasons. And at the end, the tribunal's decision on the matter will be set out very briefly. So it will be a four-prong approach. First is the party submissions, the claimant submissions. the respondent submissions, the tribunal's analysis, and then the tribunal's decision. Now, this will be for each claim. So, if there is a claim for, say, a breach of contract, then yes, there is a breach of contract or no. Then, on whether damages should be paid or not, and if yes, how much. So, it's like that. After you deal with the whole gamut of claims that are involved, then you go on to the, say, suppose the interest component. But just one thing, before we go to the interest component, see what happens is, as a principle, it is important for the tribunal to deal with every single claim. Because if they don't, then it can become susceptible to challenge. One of the parties will say, I raised this claim, but you didn't deal with it. But that doesn't mean that there has to be a mechanical approach that you have to take every single claim and say something about it. Sometimes what happens is that once a decision on a particular claim is made, decision on other claims become redundant. So you don't have to specifically deal with that. Let me give you an example. Many times what happens is there are claims for breach of representation and warranties. Meaning what? That let's say in a share purchase agreement, you had made a representation that the land that is owned by the factory is actually owned by the factory. There is no issue with title or anything like that. On the basis of this representation that you have made, the buyer of your company accepts, and on this basis they buy the company. They pay you several crore rupees, and then you leave the company. They take control. Along with the representation, what you also say as a contractual agreement, I make a warranty to you that whatever I have said to you is true and correct at the time of saying it. Third is, if it turns out to be that what I have told you is incorrect, it is false, then I will indemnify you. I will give you compensation for whatever loss you suffer because of the falseness of what I have said. Right? There may be, what happens in indemnity claims is that mostly there are limitations. That, say, for example, any indemnity claim, you should be making only within a particular period of time, say 3 years from the contract. Because it can't be that, okay, you find out that I had lied to you, or it turned out to be false, but you are going to come to me only after 10 years. That can't be. So people have a limitation. The carve out for such a limitation would be cases like fraud or negligence, where you deliberately hid something. So, how would the claim progress? The claim would first progress to say that there should be a declaration that you have breached the representation, it was false. Therefore, you breached your warranty. Therefore, you must indemnify me for an amount of 100 crores, say, for example. And because there is fraud, the contract should be deemed to be void. So there are 4 claims. But after examining both the claims, the evidence, everything, if the tribunal comes to a conclusion that no, your representation was true all this time, it was not false. So then there is no question of the tribunal going into deciding whether you breached the warranty or whether the indemnities should be granted, and so on and so forth. So all the claims would be deemed to be dealt with because you already dealt with the first one, right? A holistic approach essentially has to be taken to dealing with the claims in the award. Now, the next part is interest, which we already discussed how interest works. What are the tribunal's powers? Tribunal has to always be mindful that they are not overriding the parties' agreement in so far as the first part is concerned, which is from cause of action to award. But if there is no agreement on this, then they have the power to do it. And of course, for post award, again, the act itself says it, but it is always advisable to set out what the rate of interest is, if at all any interest is granted. The next part is, of course, the costs, which also in detail we have gone through. What kind of things has to be considered? But the tribunal should, whatever it is, if the tribunal believes that no cause should be granted, then they should give a reason for that. If they believe that some part of the cause should be granted to the respondent, some to the claimant, then reason should be given for that as well. And of course, the last thing is the signature, which also we discussed. Now let's look at a few tips or maybe considerations tomorrow if you become, if and I'm sure you will, many of you will become arbitrators. A few things that we should keep in mind, and some of this might apply to when we are drafting pleadings also. One of the things that the tribunal should keep in mind is that they should use clear and simple language. It's fine. I mean, the award as simple as it can process in simpler English, simpler language, shorter, crisper language as much as possible is always better, because it's important to have clarity to for the parties to understand what has happened. There are instances where the Supreme Court has said we don't understand what has been said in this award. There is no need, and on that basis, awards have been set aside. So it is very important that the award be clear and say what is happening. It should be consistent. There should be no inconsistencies between what is said in one part and the other part. Otherwise, it can again be susceptible to be set aside. There is no real reason for it to have a lot of flowery language or verbosity or very high level English words or something like that. As long as it is correct and legal terms are correct, it's fine. And I think this can directly translate to what we do as lawyers also. We should also always maintain simplicity. Actually, if you ask me, it is more difficult to be simple. It is more difficult to keep things brief. It is easier for whether it is a judgment or award or legal pleadings or academic papers, whatever it is. It's easier to type and think more and write more, longer, etc. It is much more difficult to make it clear and precise and short. So I think that's a personal view as far as arbitral awards are also concerned. Specifically, as far as awards are concerned, one of the things that also should be kept in mind is that there should be fewer obiter statements. What do I mean by that? I think most of you probably already know what ratio and obiter mean, but just quickly, ratio decidendi is just a Latin term for what is the finding, the binding views of the court or the tribunal. Those are the only parts which bind both the parties. But then there are certain other things that are said, certain matters of just plain opinion, which in Latin again is called obiter dicta. Obiter or opinion, just plain opinions without having any binding effect, should generally be avoided. That, for example, in a tribunal, in an award, that a party conducted itself in an unfair manner without actually coming to finding about it and just making a stray observation, it can create confusion. It can create problems during enforcement also, because there is no finding on that basis. So generally, stray remarks, observation should be avoided. One of the pitfalls, and there are some safety parts that you should keep in mind as an arbitrator, I suppose, is, and we discussed this before, that, excessive quotations from any book, judgment, and definitely from party submissions, copy pasting or excessive quotation should be avoided. You can always refer to something, but excessive quotation should be avoided. And this again it translates into pleading also. Whenever we are making any pleading, filing something before court, any petition, application, etc., generally one should avoid excessively quoting or copy pasting from which your any evidentiary document or the statute, etc., because it takes away from the narrative that you're trying to build. Because ultimately, whether you are doing it in writing or you're doing it orally, Advocacy is about persuasion, right? You want to persuade the tribunal or the judge, or maybe even your client for that matter, when you're giving opinions, that this is the legal analysis. When you infuse things like very difficult language or a lot of quotation, those kind of things, it distracts the person from your flow. You have a flow and you set it out in paper. That other person will get distracted and they will not be able to appreciate your flow if there are impediments like this in the whether it is in the award or your legal pleading. So that's one thing that you can avoid. And this is a matter of guideline. But a definite piece of caution as an arbitrator is to be very, very, very careful that you are not delegating the judicial function or adjudicatory function that you're doing. Now, what do I mean by that? Uh, Most institutional arbitrations and sometimes even ad hoc arbitrations rely on administrative assistance. The Arbitration Act allows for it, specifically allows it. What does that mean? Tribunals generally appoint a tribunal secretary, and they are very useful. They are tribunal secretaries are trained people. They are very resourceful, and they help a streamlining of the process. So they can be attached to the arbitral institution like CAC, MCI, or they may be associated with the tribunal member. Essentially, they are people who help the tribunal in the award. But that help should never be elevated to a level of replacement of an arbitrator. Uh, Meaning that the tribunal secretary should not be drafting the award or should not be granting the reasons or etc. Those kind of things, because then the award can be set aside. To put it very briefly, uh, tribunal secretary should not act as a fourth arbitrator, right? There are, if you look at some cases in international commercial arbitrations, there are actually such situations, like in the UKOS, YUKOS, UKOS proceedings, where there was an allegation that an entire portion or a very large part of the award was actually drafted by the tribunal secretary and not the arbitrator. So that can create complications. Right. And of course, now we have artificial intelligence. So we have to be very careful. And this again goes to our pleading as well, that we should not be over reliant on artificial intelligence. It is a very important tool. It should be used, but very, very carefully. I think here we come to an end on the section of drafting arbitral awards. I will then move on to the part of executing or the challenge structure of an arbitral award. So at this point, if there are any questions on drafting, please let me know. No? Okay. So we will move on to the second part. So I will deal with 34 and 48 together
Sir,
because, yeah.
sorry for the intervention.
No,
Sir,
no,
can I just ask a question? In a civil suit, normally they tell that you have to mention everything into your drafting and pleading, even before you actually it goes to the trial. Because at later stage you cannot add any kind of things. Is such kind of conditions to be kept in mind when you're actually drafting for the ADR?
Yeah, that's a very good question, Shankar. So I'll tell you very briefly this way, that number one, you can there is place for you to amend your pleadings. Arbitration Act specifically allows that. It's okay, you can do it up to a certain stage, not after that. But sometimes it depends on the tribunal, uh, and that is why it is very, very important for you to ask for a procedural order right in the beginning as to how you want the pleadings as the tribe. How does the tribunal want its pleadings? In many cases these days, what happens is, and this is very different from how we do it in civil suits. In civil suits, what we do is we file the plaint and the written statement. But as per the CPC as well, the pleadings are not to contain law or evidence, right? A pleading is a pleading. But in arbitrations, there is what we call a memorial style, which means that sometimes tribunal tells you, or it's a direction, that you will file your pleading with all the evidence, with all the legal submissions, with all the legal authorities, and all your witness statements. So everything has to be filed together. In those cases, it becomes much more difficult to then later on go and amend something. You can still do it, but you have to ask, you have to give reasons. And if your reasons are not good enough, then you may be slapped with a costs order. I hope that resolves your query.
Yes, sir.
Right. Okay, now let's come to what I think the meat, perhaps the meat of the matter, which is enforceability and challenging the arbitral award. So there are, of course, two aspects to this. One is when we are dealing with domestic awards, which are governed by Section 34 of the Arbitration Act, and the other aspect is foreign awards, which is under Section 48 of the Arbitration Act. There's also a third aspect, which is under the Geneva Convention, is under Section 57 of the Arbitration Act. But we will focus on 34 and 48 because there are very few you will have to deal with in terms of the Geneva Convention. So let's start with 34. Now, what is an arbitral award is also informed by Section 35 of the Arbitration Act. What does it say? It says that 35 and 36 together, what they say is that once an arbitral award is final, it is final. An arbitral award is final and it is binding not only on the parties, but the parties who claim through or under the party to the arbitration. And a final award is treated as if it is a decree of the court. This is why arbitration is important, and that is where it gets the legitimacy of the Indian legislature. That a private person who is not a judge, or three people who are sitting and making a decision about two other people who have set them up as arbitrators, what those three people say is not just words on paper. It is like a decree of the court. So it's a big deal, and therefore it has to it has to satisfy the high requirements of what a decree should contain generally. And this is why, if you see, and we don't have that much time, but this is why, if you see historically, courts have had a very, not a very embracing kind of approach towards arbitration, because it's such a big responsibility to give to private people to come to a decision on what is binding as if it were a decree of the court. But we have evolved over a long period of time, and now we have come to arbitrators are also very, very sophisticated. Lawyers are also very sophisticated. Parties are sophisticated. Courts are also sophisticated. So now there is a much more faith in the arbitral process. But still, it is not entirely free from all challenges, an arbitral award. So you have, as I mentioned earlier, the formal requirements I'll deal with quickly. The one is, of course, that once you have the award, you have 3 months to challenge the award. And after that, you get 30 extra days only if the court gives you condemnation of delay and you are able to make out why you didn't file in the 3 months. That is 3 months from the date of your receipt of the award. But when we deal with Section 34 itself, it says that this is a provision under which the award may be set aside. So it is not compulsory. It is not compulsory for the court to set aside if those grounds are met. That is the same with Section 48 as well. If you look at Section 48, and there is a judgment by Justice Nariman, which also clarifies that even when the grounds for setting aside or refusing enforcement under Section 48 are met, it is not necessary that you have to refuse enforcement. You still can allow the enforcement of the award. So, what is Section 34? It's easier to explain to you what it is not. Okay, it is not an appellate provision. Section 34 is not an appeal. It is not a revision. or it is not a review. It is not a procedure where you take the award to the court and say you dissect the entire award and you go into every single aspect of it and say, see, this is what the tribunal did wrong. That is what the tribunal did wrong. No, it is a very limited scope of review. And if at all an award has to be set aside, it can be done only on the very, very specific grounds that are mentioned in Section 34 itself. The review process itself has to be in a summary manner. So it's not like when you go to the Section 34 stage, it is not that you can introduce new evidence. It is not that you can ask the court to go into the factual aspects of the matter or the merits of the matter or a granular analysis. You can't call witnesses and say, please listen to this person, etc. The whole examination has to be based on what is already part of the arbitral record. There was actually an amendment, I think in 2015 or 19 for this purpose, to clarify that any objection has to be based on the arbitral record in Section 34. And you cannot go beyond that. Now, of course, the applicability of Section 34, it only applies to arbitral awards. It does not apply to orders, interim orders, or any of those things. It applies only to the final award. Any orders on interim matters, etc., if at all, they can be challenged under if there would be orders under Section 17 of the Arbitration Act, and they can be challenged only in Section 37 to the extent they are allowed to be challenged. Now let's move to the grounds for setting aside. Broadly, I think what I would categorize them this way. First is party-based. Second is procedure-based. Third is arbitration agreement-based. And the last is public policy-based, which is the dark horse. I think everyone has heard of this. But we'll come to it. And I think there was a question earlier about challenging jurisdiction. So we'll come to that also at this stage as 31, right? 34. So the first is very clear. If the award can be set aside if a party was under some incapacity. This is a rare ground, but I think it speaks for itself. If any of the parties are legally not competent, whether it could be mentally or it could be by way of age or any other reason why, say, for example, you are under the Contract Act. If you are a person who cannot enter into a contract, then most likely, if you are part of a proceeding where an award is passed and you are affected, then award can be set aside on that ground. Just to give you an example, if I remember right, I think in Daiichi Sankyo versus Ranbaxy, the Malvinder brothers, the Delhi High Court was dealing with the situation. It was a 48 enforcement of a foreign award. But I remember, I think some of the members against whom directions were passed, they were minors. So the award was not enforced against them, but it was enforced against everyone else. All the grounds were made out for enforcement, but not against them because they were minors. And of course, I will go back and check this, but you can also check them. And again, see, what I'm going to not do is discuss 48 separately because most of the grounds are similar. There are some things which are not there in Section 48, which we'll come to. So first is party-based, which is that if a party is under incapacity, the award will not be enforced. It may be set aside. Second is procedure-based. So if I hope we all have the Arbitration Act. So one second, we just go there. Right? And I'm not going as per exactly the order. Based on procedure, if you see subclause 3 of A, then if a party has not been provided notice of appointment of arbitrator or arbitral proceedings, or it is otherwise unable to present its case, right? Now, what we also should remember as a matter of context is that our whole structure for 34 and overall the Arbitration Act comes from the Ancestral Model Law of 1985. I'm not going too much into that because I think you must have already discussed some of these aspects of the influence of the Ancestral Model Law that comes into us. We have not taken everything as it is. We have not taken the New York Convention also as it is, but it is there. Parts of it are there. And we have not taken aspects of the Ancestral Model Law of 2006. These are separate studies that you might want to inform yourself just for contextualization. But many of these grounds are taken from the model law. Mostly it is quite obvious what it means as to when a party is not provided notice of appointment or the arbitral proceedings. What happens is practically how this becomes important is that there are times when proceedings are commenced. They are as per the Arbitration Act. Notice under Section 21 is issued. It is sent by registered post, etc. You might have to go to court under Section 11, get the arbitrator appointed. The arbitration commences. The arbitrator holds a preliminary meeting, issues notice to the other side. Still, if the other side does not come, then it is possible that the tribunal may proceed ex parte. Right? One thing that we should know about ex parte is that it doesn't simply mean ex parte doesn't simply mean where the other side doesn't come. Ex parte means that everything under the law required for notifying the other party, all the rights available for notification, they are given already. But the other party, by law, chooses not to come and participate in the proceedings, then it is ex parte. So proceeding can go ex parte, then can be an ex parte arbitral award also. In such a situation, the tribunal will still, a good tribunal will still always assess whatever the claimant is asking for on its own merit. They will examine the evidence, they will check the documents, etc. Only then make a final award. Now, what happens is in such a situation, if the requirements of notice, etc., are not met, if there is some cutting of corners, if uh, any such foul play is involved, or even if it's not foul play, just a matter of oversight and notice is not provided, then the award can be set aside. But it is the burden on the party who's asking for it to be set aside, and it's a big burden to explain why you did not participate in the proceeding. This is when you don't have notice. But what is important is also the aspect of you not being able to present your case, otherwise unable to present its case. Meaning what? These are situations when you are actually part of the arbitral proceedings. But for various reasons, if you are able to demonstrate that you were prevented from presenting your full case before the tribunal, then also it can be set aside. Basic principle of fairness in procedure. What kind of situations will this come in? It could be if you are able to, and these are very rare things, but if you are able to establish bias on base of the arbitrator, if you are able to demonstrate misconduct on the basis of the arbitrator or the other side, if the arbitrators don't follow the procedure that is set out under the Arbitration Act or that is set out under their own procedural orders, etc. If there is any fraud perpetrated on the tribunal, or if documents are suppressed, etc., that means you are not able to present your own case. Now, one thing that you should keep in mind is that if you have such an objection, it should be raised before the tribunal at the earliest opportunity first. You may or may not succeed, but courts are getting very strict about these kind of situations where you never raise these things before the tribunal. And then for the very first time, you come in a section 34 or section 48 proceeding and say, I was not, there was bias or there was misconduct or something like that. Courts are much less lenient in such a situations, and they're much less compassionate than when you actually raise this before the tribunal first, and then because you didn't succeed, you made out your case before the court, then they are more likely to consider it. And another practical aspect that you might want to consider is simply saying during the arbitral proceedings that I am participating under protest or I am participating without prejudice to my rights is not enough. Most times it is not enough. If there is an objection, it should be raised properly and before the tribunal. Many strategic considerations are involved. Many rights may get affected. So ultimately, what kind of objection you really want to take needs a very hard consideration from your end when you're actually participating in the arbitral proceedings. Next bit, similar, not the same, is award can be set aside when the composition of the tribunal or the arbitral procedure is not in accordance with the parties' agreement, unless the agreement itself was contrary to a mandatory provision of the Act. I think again it is quite straightforward. If the tribunal is not constituted as per what is said in the agreement, and unless the parties have already agreed, let's say agreement says there will be a 3-member tribunal, but only one arbitrator is appointed, a sole arbitrator. Then the award may be set aside unless it can be demonstrated that you agreed to it. Uh, Similarly, though it is not exactly the same, but if a sole arbitrator is appointed unilaterally, that is contrary to Section 12. Now, there is enough law to say you can't do it. You cannot appoint an arbitrator by yourself. There has to be either court or by agreement. In those kind of situations, the agreement, the award may be set aside. But there may be certain situations, say, which the Arbitration Act doesn't allow you to agree to. So those kind of agreements will not be upheld anyway. So it's important for you to understand that, and I think you must have all already gone through this, is that some parts of the Arbitration Act are mandatory. You cannot agree to delete those things in your agreement. Some parts of the Arbitration Act are not like that. Parties can agree which rules they want, which law they want to agree to, so on and so forth. Just to quickly give you an example, if an arbitration is seated in India under Section 28, if it is seated in India, you can't choose law that is not Indian. But if it is for a domestic arbitration, both parties are Indian. But if it's an international commercial arbitration, then you can probably choose. So that is a question of choice. Some places choice is available, some places choice is not available under the Arbitration Act. And if there are choices that are made that are contrary to the mandatory provision, whether it is by the tribunal or by the parties, the award may be set aside. Now let's come to the jurisdiction bit. Okay, this was a question that was asked. Initially, there were judgments to say that you must raise this objection of jurisdiction at the earliest opportunity. And you cannot raise it then in 34 if you never brought it up in the first place. The only other reason is if to do that, if parties agree to it, or if you, on something similar to that, where you can say that you waived the objection. But in 2018 or so, I think, the Supreme Court in Lion Engineering versus State of Madhya Pradesh had held, Justice Nariman only, I think, had held that there is no bar as such for you to raise a jurisdiction objection for the very first time, even under Section 34 proceedings. But obviously, you will have to make out a very compelling case as to why you were not able to do this before. All it says, I think, ultimately is that you can do it, but your threshold to explain a jurisdiction objection, setting aside based on lack of jurisdiction, will be very, very high. There has been a lot of academic criticism, etc., but that I believe this is the latest on the issue. But in any case, to the extent possible, just as a matter of safety, and again, subject to strategy, jurisdictional objections should be raised at the earliest possible opportunity. Right. Now, let's go to the arbitration agreement aspect, arbitration agreement based grounds for setting aside. First, is if the arbitration agreement itself is invalid under Indian law, under the law of the arbitration agreement. So this is a factor of arbitrability partly, and otherwise also partly to do with the Contract Act or whichever contract provision is applicable in the country of the arbitration agreement. But other than that, it's quite self-explanatory that you have to demonstrate that the arbitration agreement is not invalid. So it's a very basic requirement. What constitutes arbitrability and what law applies is now has been recently in debates about what applies, which part of the law is arbitrability law, which law of arbitration agreement applies. But I think those are slightly different discussions. But if you do want to look at what would be the law of the arbitration agreement, I think very recently the Supreme Court has discussed this in a judgment called Dis Ortho. So you might want to look that up. But otherwise, if the arbitration agreement is invalid, then the award can be set aside. And again, this is something you should ideally bring up during the proceedings, but it's a ground that is still available at 34. Second and related is that if the award deals with something that is not submitted to the tribunal, number one, either it is not submitted to the tribunal, parties have not even asked the tribunal to decide, or secondly, it is outside the scope of the arbitration agreement itself. And I would add a third one, which is if it's contrary to the Arbitration Act itself, because there are certain powers are not given to the tribunal unless the parties agree specifically. So the first two are, I think, quite clear. The first is where parties never even requested the tribunal to decide, and therefore they have exceeded their power. Second is the arbitration agreement doesn't allow them to do that because only some kind of disputes are submitted to arbitration. Mostly, as a practical matter, parties agree that all disputes in connection with arising out of etc. will be submitted. So this is a rare objection. But third is, and this is from a contextual perspective, see, tribunals are not actually courts. The awards are treated as if they were decree. And I know what I'm saying sounds very obvious, but what the courts do have is the power of doing equity to establish fairness, even in private transactions and private civil suits, commercial suits, etc. The tribunals, arbitral tribunals, do not have the power to do that. So unless the parties specifically agree. Okay, so if you see 28(2) of the Arbitration Act, what it says is the arbitral tribunal shall decide ex aequo e bono or as amiable compositor only if the parties have expressly authorized it to do so. So these are again, for some reason, very fancy Latin terms, just to which mean that the tribunal can take decisions of equity and fairness, etc., and justice, overall justice, only if the parties say that they can do it. And as a practice, it's not very common to see parties specifically saying tribunal can give equitable relief. So if they do that, then the award can also be set aside. Of course, if the reliefs that are granted are otherwise extending to parties who are not part of the arbitration agreement, to the world at large, unless you can demonstrate that they are also parties, so those kind of orders, directions, etc., they also may be said to be outside the scope of the arbitration, and therefore they may be challenged or set aside. Important thing here is that in section 34, this provision that I'm talking about, just one second. Yeah, so if you see, I'm talking about section 34, subclause 2, small Roman 4, right? Disputes not contemplated. It's a very important proviso here, which says that provided that if the decisions on matters submitted to arbitration can be separated from those not submitted, only that part of the arbitral award which contains decisions on matters not submitted may be set aside. In simple terms, what it means is that if there is some part which we are saying were not part of the arbitration agreement or reference, you can keep that aside. They will be set aside. But the other things which are part will still remain true. It's not like the entire arbitration award will be thrown out just because some parts were not uh, part of the reference. Uh, Connecting to this is a very important discussion, but it will be a very large discussion, so I will only flag it. Is the power of the courts to modify an arbitral award. Very recently, this year, the Supreme Court has clarified that courts do have the power to modify arbitral awards. Otherwise, you could probably have set aside the entire award, but there are very rare situations, the court has said, Supreme Court has said, that you can modify the award also, not just set it and throw it out entirely. So this would be the decision in Gayatri Balasamy, and I encourage you all to go through it. It's a long judgment, but it is a worthwhile read. So that's as far as Section 34's main parts are concerned. Now we come to the dark horse, as they call it, the public policy objection. I'm not going to read out the whole thing, but if you see Section 34 2B 2 small 2, an award which is in conflict with the public policy of India can be set aside. And you should also read with that Section 34 2A, which is that an arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside if the court finds that the award is vitiated by patent illegality. Now, what are these terms? This has been a matter of debate for so many years now, since the time the Arbitration Act has come, and it is still being debated as what is the public policy of India. Now, if you see the Act itself, you will see three different, there is an explanation which makes it more narrow as to what is the meaning of public policy. It doesn't mean just anything under the world. Okay, it doesn't mean if the award simply violates a legal provision Indian legal provision, that it is contrary to the public policy of India. It is not. It's a higher threshold. So I think what we can only see in the statute are guideposts. So it would be, say, if there is fraud or corruption that was involved in the making of the award, or contravention with the fundamental policy of Indian law, or if it's in conflict with the most basic notions of morality or justice. It's again, you see, even within the sub requirements, there are very high thresholds. So it is not just in conflict with morality or justice. It is in conflict with the most basic notions of morality or justice. So it's a very high threshold. And then there is a patent illegality requirement. There is a plethora of judgments dealing with situation basis when public policy is deemed to be violated or when there is patent illegality. I don't propose to discuss that at a lot of length. Sorry, there's a question of, sir, which were the sections? About public policy, is it? That you're asking? It is at section 34. I'll just put it. 2A, 2 and 2. Yeah. So these are the sections as far as public policy is concerned and patent illegality is concerned. But let me tell you broadly what it means. Okay, this is a question of what is the scope of interference by a court. I think the guidepost is an award can be set aside when the view taken by a tribunal is not only not plausible, but also that it is completely impossible for a rational person to come to that conclusion. And that is probably the guidepost that you can look at. From here, there are a lot of streams that will flow. Okay, one of the things will be that some element of evidence was misinterpreted, or there is no correct appreciation of there is no correct approach towards the evidence, etc. But also in the guidepost is that you cannot, as a even in 34 under public policy, patent illegality, all of this together, the principle is, number one is that the arbitrator is has the final word on the facts. There are exceptions which I'll tell you, but the arbitrator has the final word on the facts. The arbitrator's views and application of the law, it may be wrong. Sometimes it is wrong, and sometimes it's not wrong, but the another person or another court might have come to a different conclusion. That also is not open to challenge. It is the arbitrator's power to deal with the evidence and appreciate the evidence. In a 34 proceeding, evidence is not supposed to be appreciated, reappreciated. But if you are able to demonstrate that based on whatever is already available, there is simply no way that any rational person could have come to a conclusion based on what the arbitral tribunal has come to a conclusion. Only those situations you will find that there is a patent illegality, and in which case the award will be set aside. As far as public policy itself is concerned, fraud is a very high threshold. Corruption also, you will have to make out a very beat a very high threshold to demonstrate that there has been corruption. And corruption on whose part? On your part or the other side's part, or how is it? So that will be one. Especially because something like corruption is involved with authorities. So most likely the authority will have to demonstrate that there is a corruption, but it's a double-edged sword. So it is something that has to be dealt with sensitively, but it has to be dealt with. The fundamental policy of Indian law. Now, see, there are judgments which say that certain provisions under, say, FEMA, the Foreign Exchange Management Act, it's just because the award directs, and especially in cases of foreign awards, where if a party is getting assured returns in a cross-border transactions, generally cross assured returns are not allowed in specific situations under the FEMA. But that by itself, the courts have said, that by itself is not grounds to say that it is against public policy, because there are provisions in the FEMA which say that you can ask FEMA for that approval. So it has to be a very high threshold. If it's something completely to the Indian export policy or completely contrary to the fiscal policy, but that is a very high threshold again. So that is as far as patent illegality is concerned. Sorry, as far as public policy is concerned, patent illegality also we discussed. The most important judgments dealing with that is, I would say, Associate Builders of 2015, which had explained what the grounds for setting aside should be. But one of the grounds which subsequently, for patent illegality, was subsequently removed is what we call the Wednesbury principles of reasonableness. There's old English law on what they call the Wednesbury principles. I'm not going to go too deep into that, but it's basically certain actions that administrative or cautionary principles that administrative authorities have to abide by, meaning they cannot be arbitrary, it cannot be completely irrational, etc. But importing that principle into setting aside an award as a patent illegality ground was criticized, and rightly so, and it was ultimately recommended by the Law Commission in the 246th Law Commission report that this Wednesbury principle should not be applied, because you're broadening the scope of challenging an award. So back to what it still is, it's simple. If something that shocks the conscience of the court, something that is completely impossible, and no reasonable person would have come to such a conclusion, only then patent illegality ground is met. One of the things that, as a principle, you might want to consider is that this ground of patent illegality is available only in case of arbitrations that are not international commercial arbitrations. Now, which means that at the very same time, there could be a domestic arbitration going on in Mumbai, which has two Indian parties. There could be an international commercial arbitration in Mumbai, which has one Indian and one foreign party. But the domestic arbitration award is subject to patent illegality. Foreign arbitration, the ICA, seated in Mumbai itself, and it's governed by Arbitration Act, Part 134, everything. But it does not have a patent illegality cap or requirement not to have patent illegality. Is this valid? Is this a constitutional provision? Is this an intelligible differentia? Is there reason to treat these two differently, domestic and ICA? Why there should be a higher threshold for domestic arbitrations is something that you might want to explore. I don't have an answer, but as of now, that provision is as it is. That in domestic cases, there will be patent illegality requirement, or that it should not have patent illegality, but that bar is not there for international commercial arbitration seated in India. So, okay, I understand that we are drawing very close to the end, and I have covered most of the points that I wanted to discuss. I think as far as foreign awards are concerned, the grounds are mostly the same. What they don't have is patent illegality. Okay. Foreign awards cannot be refused enforcement on grounds of what we call patent illegality. Some formal requirements that are important is that under Part 2, you have to, before you seek an enforcement of the award, it's not that you have to file a separate proceeding for recognition and then another proceeding for execution, but the award has to have some basic requirements. First is under Section 44 of the Arbitration Act, which set out what constitutes an award as per the New York Convention, and only those foreign awards are enforceable in India as far as the New York Convention chapter is concerned. One of the important things over there is that the country where this award is passed has to be notified as a reciprocating territory by India. So it's not enough that the other country where the award is passed is a party to the New York Convention. India is also party. There are many parties to the New York Convention. But the country has to be notified specifically by the Indian government in a gazetted notification. Only then that award will be enforceable in India. Which countries are designated is something you can find out. There is a gazette notification for that. That is number one. The other is under Section 46, the award should be final and binding. It's 46 and 46. It should be final and binding, meaning what? It's simple. In India, an award is passed, it is subject to 34. So until the time of our challenge ends, you cannot enforce it. So there may be similar requirements in, say, Singapore or UK, wherever else. Until the award becomes finally executable, you cannot ask for enforcement in India. And lastly, under 47, you have certain formal requirements that you have to produce a copy or at least a certified copy of the award and the arbitration agreement. Other than that, under 48, the grounds are very much similar. Refusals for enforcement of foreign awards is very rare. We have been consistently, India has been upholding foreign awards. Right from, say, if you check the Supreme Court's decision in Renu Sagar, which was, I think, in the 60s or so, where they developed this principle of public policy. What is public policy and why it is limited? That it only applies to fundamental policy of Indian law, etc. So it is important that you take a look at that decision. All the way up to very recently, say, decisions like Vijay Karya of the Supreme Court in 2021, where they refused to interfere or refused to take on, or rather allowed enforcement of a foreign award, even though there were objections in terms of FEMA and some requirements not being met, etc. But one of the rare refusals recently, if you ask me, was this decision called NAFED versus Alimenta, National Agricultural Cooperative Marketing Federation of India versus Alimenta SA. This was actually a 31-year-old award, but it was being dealt with in 2020. So the Supreme Court found ultimately that the contract that the parties were involved with, one of the aspects was for NAFED to supply some goods to Alimenta. For that, this company NAFED, they had to secure an approval or license from the government of India. That license was refused by the government for whatever reason as a policy measure. And then NAFED could not comply with its obligations. And therefore, the other side, Alimenta, said this is a breach, etc. And the tribunal upheld that breach. Ultimately, in the Supreme Court, remember, this was being assessed not under the current Arbitration Act, it was being assessed under the 1961 Foreign Awards Act because it's an old award, but the principles of Renu Sagar are still alive even that time. They were available. But the Supreme Court said they went into the contract itself and they found that the contract was actually a contingent contract, that the contingency was the government of India could or could not have given their approval. So the tribunal's decision is contrary to public policy and therefore it should not be enforced. So it is a rare decision. I think it does not discuss Vijay Karya or the decisions that came before it, but it's an important decision where enforcement was refused. I think the last part that I had to say a few words on, and there's not a lot, but that is in terms of the execution of an award, the actual execution of an award. So how it works generally is that when you have an Indian award or you have a foreign award actually, there is no real bar as to which court you go to, but it is guided by a certain few practical things as well. One is where are the assets of the award debtor? Because see, if you have a money award and the other side is not complying with it, first thing you might want to do is to attach properties of the other side and then have those properties sold and get monies towards your award, your compensation. So now there's some element of strategy also involved here. So if you know that the other side is going to dispose of properties, is going to put it in somebody else's name so that they don't have to pay for it, etc., then you might have to also file post award section 9 applications to get interim relief immediately to say that none of the properties should be dealt with. As an award debtor, if you really do have grounds for the award to be set aside and you believe that there has been fraud or corruption or something, or some whatever reason that you think the award is not right, then you may go under section 9 and request that these properties should not be attached and should not be affected, so on and so forth. So I'm just giving you examples of what preservatory steps can be taken or prior steps can be taken. Apart from that, I think the execution requires that you sometimes, as a practical matter, even when you're commencing the arbitration, right at the time of commencing the arbitration, parties sometimes engage asset tracing agencies, etc., so that they already have a profile for what properties are owned, where are those properties, etc. It's practically also what happens is you file the execution application, and even though you may know that a particular property belongs to somebody, that other side, award debtor, it has to be proven in court. It can become a question in court. So a lot of times, one of the requests that you have from an executing court is that please direct the award debtor to file a disclosure affidavit. Disclose on an affidavit what are my properties, what is the valuation of those properties, and then you seek relief in terms of those properties. Uh, Asset tracing, you trace the assets. There's a question of, yeah, I think there's a question, how does an arbitrator draft an award to minimize the risk of non-enforcement, conflict with public policy, etc.? See, there's no straight answer to this, but one thing I can tell you is that when you're drafting an award, you should draft, or when meaning the tribunal is drafting an award, generally what happens is that they are not going to draft only from the fear of it being set aside in some other country's public policy. But that being said, as a lawyer and as while making submissions, etc., you will also, of course, make submissions in a manner to ensure that the award, the final relief that is being asked for, is either it's not in contravention with Indian public policy, or if you're the opposite side, you will point out that if you pass this award, this will be contrary to public policy. One decision that you might want to discuss or take a look at is the Anupam Mittal dispute that took place in Singapore, where the Singapore courts held that a dispute that actually does involve some elements of or possible elements of operation mismanagement. They can be dealt with in Singapore, but and Indian law didn't apply. Even though under Indian law, O&M disputes cannot be arbitrated. So they went ahead in Singapore, but in India, our court, Bombay High Court and NCLT said you cannot do this. So there was a conflict. These questions are not very straightforward, but yes, ideally a tribunal should consider if something is going to be completely contrary to India's public policy, and it should be avoided. I think that's pretty much about it. And I think, sorry, I've also crossed the time. But if there are any quick questions, I'm happy to address them.
Yes, students, if you have any questions, you can just unmute yourself and ask the questions, or you can drop it in the chat box. I think so. No questions. It was self-explanatory. The session was quite self-explanatory. So elaborative one.
I hope there was not too much of an information overload, but if there's, I hope it was helpful. I think there is one question. After attaching the properties, what will happen? See, what happens is, after, number one, you get the properties attached, then you sell the properties. So you get a court order to sell the properties. Yes, will they sell it and off and pay the party? Yes, you will have to get a court order to have the properties sold, and then those amounts will be adjusted against your claim. So all this is governed by the CPC. Then you go into the stage of this. It's the same for civil suits. So yes.
So I think so. We can move to the validatory session, sir. Shubham, sir.
Okay. Thank you, Ritvik, sir. It was a wonderful session. Thank you so much. So, I'll start with a slok. Anudvekaram vakyam satyam prihitam chayat swadhyayabhyasanam chaiva vangamayam tap uchyate. Words that do not cause hesitation, that are truthful, pleasing, and beneficial, and the practice of self study. These are said to be austerity of speech. Today's theme of Phalasiddhi has been a profound reminder that justice is hollow if unenforced. Much like Lord Krishna's wisdom, that speech must be truthful, pleasing, and beneficial. We are reminded that enforcement too is the voice of justice, ensuring that what has been decided does not remain mere words but becomes living reality for those it impacts. We have learned that arbitral awards, when enforced effectively, do not just resolve disputes, they build trust in the system, they save society, and they uphold the dignity of law. Over to you, sir.
At this juncture, it's my privilege to extend heartfelt gratitude. We are deeply thankful to our Dean and Principal, Dr. Ujwala Bendale ma'am, Vice Principal, Dr. Jyoti Dharam ma'am, IQAC Coordinator, Vidya Dhere ma'am, whose unwavering encouragement and constant guidance has helped us. A special thanks to my colleague, Mr. Shubham Tripathi sir, without whose vision this course could not have been crafted. A very special thanks of note to today's resource person, Advocate Ritvik Kulkarni sir, whose professional expertise has enlightened us and inspired us to embrace arbitration as a living, evolving practice of law which upholds justice and dignity. On behalf of the organizing team, I sincerely appreciate the presence of all the dear participants for the active engagement. With these words, we formally conclude today's session of On Falasiddhi, because winning is not just enough, justice may be lived. Thank you, everyone. Thank you, Ritvik sir, once again.
Thank you,
Thank you.
sir.
Sir, one for snap is required, sir. Rohit sir,
Yes,
please.
all the participants are required just to on your cameras. We'll have a group photo. Ansh, you can help us with the snap. Thank you, everyone.
Thank you. Thank you so much.
Thank
Thank
you,
you,
sir.
Ritvik sir. Thank
All
you so
the best to
much.
everyone. Thank you so much.
Thank you so much.
Thank you, sir.
Bye.
One announcement for all the participants, that we have shared the problem on the group, and we have also made the groups. So whoever are there in the groups, you just prepare yourself for tomorrow's mock arbitration. Tomorrow's mock arbitration will start at 5 o'clock. So you'll get the links by morning. So tomorrow's arbitration is at 5. And if anybody has any query regarding how the mock arbitration should go, you can coordinate with Ansh Verma, student coordinator, or you can call us also. Basically, we have made teams of three. So two participants will be the they will be doing the arguments, and third will be the arbitrator, who is going to write the arbitration award. You have to be prepared with your arbitration award. Tomorrow you'll have to present your arbitration award. So this will be the scheme which has been already published on the groups, and it has been told time and again. So please be ready with tomorrow. And if anybody has any doubts, you can just ask across. And just on the group, confirm when you are ready with your team, so that tomorrow we'll line accordingly. Is that okay, sir? Shall we end?
Yes, sir. Yes, sir.
Okay. Thank you, everyone. Thank you. Thank you, sir. Thank you.